Colm and Owen were talking about, but also different to the title that I gave Owen months ago. So I'm going to kind of give you a report on a project that actually the three of us were involved in, which is the Northern Irish Feminist Judgements Project. And this is the picture of the cover of the book, which will be published at the end of the year, arising from that project. And as you will know, if the publisher has produced a cover, it has to happen, right? This thing has to come out. I like this picture, and I like showing it because I'm hoping that one day somebody will email us to say, I'm the woman in the picture, right? And so this is a picture of an enormous papier-mâché judge, which was part of a pair which used to be wheeled out at various protests, particularly around the X case and the abortion cases in the 1990s. The other, you can guess who the other part of the pair was, an enormous papier-mâché bishop. And these were huge. There's definitely more than one woman in there. And the photographer who took it is Rose Comiskey, who recently, last year had an exhibition called Against the Tide, which was her photography of feminist activism. And she'd said she wanted to take a picture, a sort of a grander scale picture capturing the ugliness of the papier-mâché judge, and she just happened to capture the moment when the head pops out, this moment of sort of excitement or surprise or fun. And the reason we picked that picture rather than, the image of Lady Justice or something a bit more neutral, was that we liked this kind of the surprise of the young woman occupying the sort of iconic judicial role. And one of the things that we've been thinking about in the Feminist Judgements Project is how we kind of, those of us who are involved, related to that idea of playing with the judicial role. So I should tell you first of all what a Feminist Judgements Project is. Feminist Judgements Projects are, there's been one in Ireland and Northern Ireland, obviously, one in Australia, originally one in, Great Britain. I think there was one Welsh and one Scottish judgment, but really an English project. And the point of a Feminist Judgements Project is that you bring together a collective of feminist academics, activist practitioners, who select a number of legal judgments that they feel were important for reasons connected to women's rights or gender, sexuality more broadly, and they rewrite them as if there had been a feminist judge on the bench. So this is what we did. We had a collective, obviously involving men as well as women, and we held a number of interdisciplinary workshops in partnership with five schools, the School of Law at UCC, the Transitional Justice Institute at Ulster, Queen's University Belfast Law School, UCD Law School and School of Equality Studies, and the School of Law at Griffith College, Dublin. And at these interdisciplinary workshops, we presented our judgments, our rewritten judgments, as we were drafting them, to a range of audiences, and in particular scholars from other disciplines, poets, artists, and judges. These are some photographs from some of the workshops we held. You may recognise members of the Irish judiciary in the bottom photograph, but in the top, this is the beautifully appointed moot courtroom in the law school in UCC, and the people occupying the bench are actually poets. You might recognise the local Galway poet, Sarah Clancy. So after all of these collective deliberations, we have produced a collection of 26 rewritten judgments and commentaries, and the point of the project, as I said, is that we rewrite the judgments not necessarily as if there had been a woman judge on the bench, though of course in many of the judgments we were rewriting there was no woman judge on the bench, but as if there had been a feminist judge on the bench. And we allow ourselves some leeway, so we may be imagining dissenting judgments or we may be imagining appeals that did not happen, but there is a limit to the amount of imagination we allow ourselves. So the point of a Feminist Judgements Project, very briefly, is that you subject yourself to all of the same constraints within reason which bound the original judges. So you have to use the same law. So for example, I rewrote the McGee judgment, which is from 1973. I had to use the law as it was in 1973. You may only use political, social research materials that were available at the time. You may only use the arguments which were made by the parties themselves at the time, though you may, of course, bemoan the absence of particular arguments in your judgment if you wish. You are bound, of course, by the rules of precedent, statutory interpretation, and so on, that bind real judges. And then, there are elements of our own concern for the plausibility of our judgments. Because one of the reasons you do a Feminist Judgements Project is you want to make certain statements about the indeterminacy and the openness of law. So you want to demonstrate that even with the law at the time, it was possible to reason the cases differently. And that often means that it's possible to produce a different outcome, that a different party wins than won originally. Sometimes it doesn't mean it's possible to produce a different outcome, but it is possible to produce a judgment which is better from a feminist perspective. And I'll talk about that betterness in a particular way in a bit. You'll also want to, if you can, put some aspects of feminist legal theory into practice. So many of the judgments will be talking about autonomy, agency, dignity, equality, particular rights, notions of relationality, and so on, in distinctively feminist ways. And the point of writing rewritten judgments, rather than simply writing articles about the judgments, is to engage in that practice of judicial reasoning and to show in very practical ways that things could have been done differently. And that in itself, I know from my own experience of teaching law from the English project at Kent, it produces a unique kind of teaching tool. And there's something very powerful about being able to put the original judgment next to the rewritten feminist judgment and allowing students to discuss what the differences are and who, which judgment is more just or better fulfills the purposes of a particular area of law, and so on. Recently at DCU, they held a feminist moot, which was based on one of the rewritten judgments from the collection. And something similar has been done at Durham. So they're very useful teaching materials that, if we say, following Owen's invocation to investigate the concrete ways in which particular judicial cultures have operated, the idea of producing a rewritten judgment is tremendously powerful in that way, in a way that perhaps other more traditional forms of academic writing or scholarship can't quite be. So what I wanted to talk about was something which is distinctive, or which we said was distinctive about the Northern Irish Feminist Judgments Project when we started, which was we wanted to think about the ways in which judges have been involved in national identity projects. So in what ways have judges and judicial discourse contributed to, I suppose, the politics of who we are? And I'll talk about what I mean by that in a bit. And that's something, that kind of talking about the judicial engagement in politics of identity rather than simply the judicial role in terms of the manufacturing of particular kinds of law, is not that's not a set of questions that other feminist judgments projects have sought to address. So what might the connections be between judicial craft and national identity? The first thing is that there's plenty of feminist scholarship charting the various ways in which the Irish state, in its many incarnations, has engaged in legislative or governmental enforcement of gendered social roles and has punished transgression of designated gendered social roles. Neera Yuval Davis is a very well-known scholar who talks about the relationship between the enforcement of particular behaviours, women's behaviours, and how they serve the nation state. So we know that we have particularly controversial laws in areas of maternity and the family, sex and sexuality, control of the body, restriction of women's autonomy, punishment of various kinds of foreignness, which have served particular state purposes. So if you look at feminist scholarship in this area, there tends to be an awful lot of focus, for instance, on post-independence legislation, which restricted women's freedoms. For instance, the 1935 Criminal Law Amendment Act, which prohibited various forms of expression of sexuality, but also restricted access to contraception. The exclusion of women from juries is another famous example. We often talk about the provisions of the 1937 Constitution, which obviously sought to underpin and undergird performance of particular social roles, so we focus on the idea of the woman's place within the home. Another area which has attracted an awful lot of feminist comment, obviously, is the Eighth Amendment, and the idea that the Eighth Amendment was a mark of a certain kind of backlash against various forms of feminist progress, which sought to reinstall mandatory performances of maternity or refusal of reproductive autonomy. So there is a mass of scholarship which talks about the relationship between law and lawmaking at the legislative and constitutional level and structural injustice against women or the mandating of performance of particular maternal and reproductive roles. But less has been said about the ways in which judgment, processes of judgment, aspects of judicial craft have interacted with those projects. We do know, and there's a fair bit written, particularly in popular political work, that women have, and women's movements have, at various points engaged with the courts as a means of challenging or seeking to change or seeking to contest legislative projects of the kinds that I highlighted there. And one of the things that we wanted to highlight was the ways in which women and women's movements have gone to court as a way of performing alternative Irish identities to the ones which were being mandated by the state at the time. So you can think of sort of iconic women litigants who we highlight to students, like Mrs. McGee, for instance, who was resisting a state onslaught against reproductive freedom and was suggesting that at least married women should have particular kinds of entitlements to determine the number and spacing of their children. Or you can think about Catherine Zappone and Anne-Louise Gilligan's case, which obviously was part of a bigger process of reimagining what the legal shape of the family should be and whether it could encompass same-sex relationships. Or you can think about Eileen Flynn, whose case, again, an iconic case where she was contesting these notions of how far an employer could go to require particular forms of behaviour, particular forms of compliance with morality of an employee. So we do think about courts as spaces where women have attempted to perform alternative Irish identities with varying degrees of success. We can also look at cases, and again, some of these have been rewritten in the collection, which were used by regressive forces to attempt to suffocate particular alternative performances of femininity. So, for instance, one of the pieces which is rewritten in the collection is a report on the Kerry Babies Tribunal, which was a very famous kind of example of violent backlash against Joanne Hayes as a particular expression of unmarried motherhood and unmarried sexuality. Or Colm was involved in the rewriting of the Vic Mahuna case, which was again a case about the state's potential support for unmarried mothers. And obviously, again, this is an area where feminist scholarship is rightly sceptical of the role of the courts. So Gillian Rose, the feminist legal theorist, talked about how important it was for women not to make the mistake of fantasizing love in the state. So thinking that the judges will always help us to achieve our transformative social goals. But nevertheless, we did recognise that it is important for feminism, particularly in Ireland and Northern Ireland, to understand how the courts have been used as part of those processes of contesting oppressive social forces and trying to find space for different performances of Irish female identity. So what we wanted to try and investigate, or what I'm trying to investigate at the moment, is how do we understand the tension between judgment as sometimes a critique of particular legalised identity projects, but sometimes also complicit in the maintenance and securing of particular legalised identity projects. Richard Devlin has written that one of the ways that we can think about cases is as contestations between particular kinds of identity or particular performances of citizenship or motherhood or whatever identity is at stake. And he says the purpose of judgment is to bring closure to the communication. So you hear the arguments, you have the contest, and then the judgment closes down, or is supposed to close down, the back and forth. Of course, we can think of the fact that actually, in the context of the feminist movement in Ireland, sometimes cases have actually been a spark for later contestation. So, for instance, if you think of the abortion clinic cases in the 90s, that then led to all kinds of important feminist organising, many of the echoes of which are still felt today, even in the Repeal the Eighth Amendment case. But for the purposes of the law, one of the functions of judgment is to provide the definitive statement on where the constitutional or legal balance lies now, which identities can be recognised by law and which cannot. And so what we were trying to think about in this project was, you know, how can we start to theorise, even loosely, judges' involvement in those politics of identity from a feminist perspective? So, I mean, certainly one way or one route into it would be to think about particular judges or groups of judgments, which have directly engaged in questions of judicial agency and identity. So you can look at somebody like, for instance, Hugh Kennedy, who's the first Chief Justice of the Free State, who wrote a great deal about and spoke a great deal about his ambitions for creating a distinctively Irish law, which would be something different from the inherited common law, and who was engaged in that project not only in his judgments, but, for instance, in his involvement in legal education in the King's Inns, and even things like his attempt to have a new set of judicial robes designed, which would be different from those inherited, right, from the British. Or you can look at somebody like Mr. Justice Gavin Duffy, who famously spoke and wrote about his belief that the common law, which had been inherited from England, should be, I suppose, reorientated towards its natural Catholicism, which was more befitting of the ethics and morality of the new state. And this is something the poet Paul Durcan has written a number of poems about his father, who was a circuit court judge, where he focuses very much on the idea of the judiciary as sort of performative of, and I'm not making this up, of a kind of a virile Fine Gael Catholic masculinity, right? And, you know, there are bits and pieces have been written about that too. You could also talk about the likes of Carúil O'Donnell, or particularly Brian Walsh, and their attempt to create a constitutional rights jurisprudence which was distinctively Irish, and of course the backlash or the subsequent change in judicial philosophy which occurred in the generation afterwards. Or you could look at like particular areas of practice. A very good example is the law of nullity, for instance, in the lead up to the legalisation of divorce, where you see judges actively struggling to try and fill in that gap between the law of the church, the law of the state, the inherited common law. So that's one place you can go, to those places where judges are openly admitting, in this space, I am directly engaging in the process of creating a distinctively or specifically Irish law. But you can also start to think about the places where, even though judges are not trying to create an Irish law as such, they are clearly interpreting the law against a background of certain suppositions about Irishness, Irish society, Irish identity. So, in particular, feminist judgment as a set of methods is interested in the things that judges say about what is common sense, the things that judges say about the people, as we talked about earlier, and what their will might be and how that will might be discerned, the histories that judges give in their judgments of particular legal issues, the moments when judges talk to us about the progress that we've made. A side issue, for instance, that's important is the Irish reliance on judges to conduct particular commissions of inquiry and particular tribunals. I mean, for instance, we can think about issues of historical gendered institutional abuse against women. Judges have sat on, for instance, Miss Justice Yvonne Murphy, I think now will be on her third such commission of inquiry, Ms. Justice Maureen Harding-Clark's involvement in the symphysiotomy redress scheme and so on. We are relying on judges increasingly to start to tell us something about how we are resolving historical issues. And it's interesting to think about as well the ways in which law is used to naturalise, in particular, exclusion of women, forgetting of women, omitting women, women's knowledge of particular kinds of social issues. And these are the kinds of things, I think, which have been dramatised better in literature, actually, books like The Heather Blazing and Edna O'Brien's Down to the River, than they have been in legal scholarship. So what we tried to do was we tried to think, and I'm going to have to blitz through this because I've been babbling on for much longer than I thought, but is to think of the Feminist Judgements Project as potentially a feminist response to judges' involvement in those kinds of things. So I'm just going to highlight a couple of the kinds of things that we did in the Judgements Project. One thing is to just start to include women in judicial narratives about what are considered to be neutral social roles. So, for instance, Aoife O'Donoghue rewrote the judgment in Magimsey, which is a judgment about citizenship and loyalty and unionism, and in that judgment, Mr. Justice Donald Barrington gives a kind of a potted history of the conflict in which everyone who occurs in the conflict, who takes part in the conflict, is a man. And so what she does is she tells not just an alternative history of the conflict, but she mentions the fact that there are women in Northern Ireland and women in Ireland, and that they were involved in peace building and community organisations and conflict and so on. And so even though that doesn't change the outcome of Magimsey as such, it changes the tenor of what is at stake. Some other examples would be to sort of talk about the harms of particular identity politics. So when Tanya Ní Bhurtha rewrites the judgment in Foy, the gender recognition case, Mr. Justice McKechnie's original judgment was very good, but Tanya spends more time on the facts of Lydia Foy's life and highlights in particular some of the kinds of wounds that Lydia Foy suffered as a child because of growing up in a particular kind of patriarchal state. And one vignette that she picks out, which isn't in the original judgment, is a discussion of Lydia Foy's distress in childhood of not being able to be in the girls' group for communion and not being able to wear the communion dress, which is, again, a social fact, a performance of, or a required performance of gender. Another thing is to point out, actually, those overt moments when judges enforce particular identities on women. My favourite, she said sarcastically, is BJM and CM, a nullity case in which Mr. Justice Flood described a woman as beautifully walked, as likely to have had an aura of sexuality about her in her youth, as having reached the zenith of all womanhood by becoming a mother in the course of her long marriage. Obviously, when Vicky Conway rewrites her judgment on Kerry babies, she emphasises the ways in which Mr. Justice Kevin Lynch repeatedly undermined the credibility of Joanne Hayes in ways in which he did not seek to undermine the credibility of the Gardaí who were so brutally investigating her. In O'Keefe, Maeve O'Rourke retells the facts of what happened to Louise O'Keefe, and in particular, she reorientates Mr. Justice Hardiman's judgment, which spends a lot of time emphasising that child sex abuse was of the kind that Leo Hickey was involved in was exceptional. She reminds us in her rewriting of the judgment that it was not exceptional, but was widespread. And what she does is, instead of treating the abuse of children as something separate, she links it into the abuse of women more broadly in Irish society at the time, the Magdalene Laundries and so on. The other kind of, I suppose, final kind of thing is that we've all sought to try to remake and expose particular legal remedies and categories which are rooted in identity and try and repurpose them for sort of feminist projects. So a lot of us found ourselves working with the constitutional notion of the family, which constitutionally is an institution, a grouping, which is to be protected. And lots of us found ourselves rewriting the family not as a group, not as a kind of little fortress against the state, but as a set of relationships which the state protects because we feel that it does some good for the individuals who are enacting those relationships day by day. My favourite kind of one, which is the last one that I'll two and then I'll sit down. Mary Donnelly does a really clever thing in her rewritten judgment. So in Mary Donnelly's judgment is PM, which is a case about a woman who wanted to refuse life-saving medical treatment for religious reasons and then lost consciousness, and the decision was kind of made effectively in her absence. And one of the things that Mary Donnelly does is she says, well, this judgment should be rewritten so that this woman has more of a voice. What I'm going to do is I'm going to take Spuck and Coogan, which gives standing to the unborn, on the basis that some people are not able to represent themselves, and so the state must provide representation for them. Now, if this applies to the unborn, surely it must also apply to a born woman whose autonomy is at stake. I really liked that repurposing. The other final thing that Maeve O'Rourke does, which is excellent, is she talks about O'Keefe as a vicarious liability case, and then she has a little paragraph at the end where she muses about how sad it is that nobody thought to make the argument about inhuman and degrading treatment, because probably that would have succeeded. And what she does there is she takes Louise O'Keefe from the space of kind of child to whom we might owe a loose civil obligation to the space of victim of human rights abuse and serious, proper, masculine human rights abuse. Right? So she takes torture, which is usually held away from women as a particular remedy, has been held away from symphysiotomy, Magdalene Laundries and so on, and makes it part of Irish law. So what we're kind of discovering is that there are, if you are attentive to the politics of identity and the multiple different ways in which they work through judgments, it can have consequences for how you do judging. And so what we're hoping is that the book, once it's published, although some of the judgments are floating around online as well, is that it will start to help law students in particular to think about how we can enact dissensus even within the very, very cramped confines of Irish law. So that was less structured than I wanted, but I promise I'll sit down now. All right, thank you very much.